Welcome to the latest edition in our video interview series here at iConnect. My name is Richard Albert, and today's discussion is going to be about Italian constitutional law, developments in Italian constitutional law. And my guest today is Cristina Fasone. Cristina is a postdoctoral fellow in the Max Weber program at the European University Institute, and she also teaches a course on comparative public law at the Guido Carli University in Rome. Cristina, it's a pleasure to have you here with us to talk about developments in Italian constitutional law. Thank you so much.
Thanks, Richard. Thanks a lot for this.
Cristina, you're welcome. You're welcome. Let's begin. What are, would you say, today, the main issues, the main items of interest in respect of constitutional law in Italy?
Yes, there's a lot that is debated today in terms of current developments in Italian constitutional law. To start with, I think one of the most debated issues is the current attempt to reform the Constitution. If it will succeed, it is the most significant reform of the Constitution, the second part of the Constitution we have since 1948, when the Constitution was enacted. Also debated is the new electoral law, passed just a few weeks ago. Of course, it is linked to the constitutional reform, because if the constitutional reform enters into force, then the Senate, the second chamber, will no longer be elected. So this electoral law only applies to the Chamber of Deputies, which is the lower chamber. And whereas so far Italy has had a perfect and symmetric bicameralism, where both chambers were elected, they have exactly the same powers, and both are linked to the government by a confidence relationship. So the two reforms are closely connected. However, the electoral reform has just been passed, so this is why the scholarly debate is focused on the electoral law, whereas the constitutional reform is still underway.
So this must be a very exciting time for you, very interesting time, because your own scholarship focuses on bicameralism, and particularly upper chambers. So I'll look forward to reading more of your work about this particular reform and also the electoral law. But the electoral law, Cristina, could you tell us about how it would work? What kinds of changes in particular would it visit in Italy?
Sure. The new electoral law is still based, as in the past, on a mainly proportional system. Although the results given to the majority, because of the majority bonus, will be, I think, mainly majoritarian in terms of effects. I also have to highlight the fact that this has been discussed for years. And so the electoral law, which is still in force, because the new one will apply starting from the 1st of July 2016, was heavily criticized. There was an attempt to repeal this law through an abrogative referendum, which, however, was declared inadmissible by the Italian Constitutional Court. And also the current electoral reform has been triggered by a very important judgment of the Italian Constitutional Court, Judgment 1/2014, which has partially declared the electoral law unconstitutional on the ground of the lack of any threshold for assigning the majority bonus when votes are converted into seats, as well as the very troublesome relationship between citizens and representatives that the past electoral law created, because citizens were asked to vote on closed lists, so predetermined by political parties. Also, these lists were very, very long, and it was possible for candidates to run in several constituencies at the same time without limits. So the Constitutional Court considered this law unconstitutional. This was also debated, and if I have time, I will explain to what extent this was part of the debate. But the new electoral law, I think, takes into account these clear warnings of the Italian Constitutional Court. So that it's important, the fact that there are limits now to the assignment of the majority bonus. And it can also be that if no political party has reached at least 40% of the votes on a national basis, there will be a second ballot. Otherwise, the majority bonus can be assigned. It's more than a majority bonus. I will say that additional seats are assigned to the most voted party. So the new electoral law is deemed to ensure governability and stability of the government, so that a clear majority will be formed in the Chamber of Deputies. Indeed, one of the problems of the functioning of the Italian constitutional system for years has been the instability of the government. So this electoral law will help to fix, I think, this problem. I must admit, however, that there are also scholars that criticize this new electoral law for being too majoritarian in its effects. Another point that I would like to remark shortly is the fact that our constitution, the Italian constitution, doesn't predetermine the adoption of a specific electoral system, so that the parliament was able to choose majoritarian or electoral or proportional formula. But this, I think, ensure more stability is the primary objective, as well as to try to fix the problem of the lack of relationship between citizens and representatives, because the electoral list will no longer be closed, and so citizens will be able to choose who they are going to elect.
Do you think the law is ultimately going to prove beneficial, positive?
I think it will help to solve one of the traditional problems of the constitutional and political system in Italy, which has been a very high level of fragmentation in parliament. The fact that the Italian system has usually been ruled by very fragmented coalition governments that created their alliance either before or after, but were not really cohesive. So I think that the electoral law could be beneficial in order to overcome this problem of fragmentation and governability.
So it doesn't take effect until 2016, so we have some time still before we see the effects of the new electoral law. Cristina, if I may just move now to the Constitutional Court. Could you tell us a bit about the Constitutional Court's case law on purely domestic issues on the one hand, and on the other hand, on issues in connection with the EU and international law? What have been some of the major developments in terms of the Constitutional Court's case law?
Thanks, Richard, for asking this, because I think there are very interesting developments in the case law of the Constitutional Court. On purely domestic issue, I will say, in particular, in matter of rights, and due to the deadlock in the legislative process, also because of the perfect bicameralism we have, the Parliament was not really able to address some crucial issues that then reached the court, the Constitutional Court, and so the court finally was able to decide on those issues. For instance, the Constitutional Court took a very important decision last year in matter of assisted procreation, so heterologous insemination, as to allow this practice as to make it possible. So it acknowledged this as being in compliance with the Constitution. Also, the Constitutional Court has faced the implementation of the latest constitutional reform we had, which is a constitutional reform introducing the balanced budget clause into the Italian Constitution. And this leads me to more clear relationship between national constitutional law and EU law, because it is true that this is part of the constitutional reform of 2012, but it is also true that due to the Eurozone crisis, this reform was at least partially triggered by EU international law. And the need to restore sound public accounts in most Eurozone countries, namely Italy, which was under a very strong financial and speculative attack. So the reaction was to adopt this constitutional reform, and of course, this changes standard for review on the part of the Constitutional Court. The reform has been in operation as of the 1st of January 2014. So in the middle, there was a time where austerity measures were adopted, but the new balanced budget clause was not in force yet. And I see very interesting development in the case law of the Constitutional Court, not always in a very consistent way, trying to balance, for instance, social rights, the protection of social rights, with the need to respect European obligations, and finally, the new balanced budget clause. Also, interesting judgment, if we look at international law, have been taken by the Italian Constitutional Court for what concerns the interpretation of the European Convention on Human Rights, because the Constitutional Court in 2015 has defined set of standards as for the interpretation by ordinary judges of Italian legislation in conformity not only with the Convention but with the case law of the court in Strasbourg. So the Italian Constitutional Court has been quite careful in defining clear boundaries on whether this case law from Strasbourg can be really implemented or not, based on the Italian Constitution. And finally, there has been quite striking judgment, I would say, on in the field of international law. In 2014, for the first time, the Italian Constitutional Court has used its counter-limit doctrine against international law, even against the law that ratified the UN Charter, so the UN Charter, and the case was unexpected in that the counter-limit doctrine, which is quite well known, postulates that actually was invented with regard to EU law. And it said that there are supreme principles enshrined into the Italian Constitution that cannot be superseded, that cannot be breached by EU law, which in theory enjoys primacy over the constitutional system. This doctrine and the Italian Constitutional Court has always threatened to use these counter limits against EU law, but it has never done so. For the first time in 2014, it adopted this decision against international law, in particular against the customary rule that according to which states enjoy immunities from civil jurisdiction of other states. And there was an issue dealing with compensation for Italian citizens due to gross violation of fundamental rights during the Nazi occupation of Italy during World War II. So in this case, the Italian Constitutional Court contradicted the judgment of the International Court of Justice.
So we've talked about, Cristina, some of the Constitutional Court's case law, not only on domestic matters, but also in respect of EU and international law. We've talked about developments in Parliament. I wonder, Cristina, what is the relationship, the status of the relationship between the Constitutional Court and the Parliament? Is it a collaborative relationship? Is it a confrontational relationship? Has there been an evolution in the way the two interact? What is the current state of the relationship between these two institutional branches of government?
Well, the Italian Constitutional Court has usually been quite deferential towards the Parliament, namely trying to avoid, wherever possible, to declare laws unconstitutional, maybe to send warnings to the Parliament to amend the legislation, otherwise next time the court will judge the law unconstitutional, also forcing the ordinary judges to adopt, wherever possible, an interpretation of the law in conformity with the Constitution, and only if insofar this was not possible, to ask the Constitutional Court through a preliminary reference proceeding whether the law was really unconstitutional. However, I have to say that there is no direct relationship in terms of access to the Constitutional Court between the Parliament and the Constitutional Court. There's no sésame parlementaire, for instance, so parliamentary minorities cannot reach the court, nor the Speaker of the House is entitled to ask the Constitutional Court to review legislation. And also, I think a very important development in this regard is about the effects of the decision of the Constitutional Court, because this decision usually have retroactive effects. So they also have huge implications that then have to be fixed by the parliament. And so this is also why the Italian Constitutional Court has usually been very careful or cautious before decided to annul a piece of legislation, also in terms of financial implication. And in a very important decision of 2015, February 2015, it has been one of the first time in which the Italian Constitutional Court, based on a strict proportionality test, and this is also new in Italian constitutional case law, has declared that a specific piece of legislation, tax law, was going to was declared unconstitutional, and the effect of the unconstitutionality of the legislation will start the day after the publication of the decision, so as not to make those effective retroactive. So I think this was a very important development, which, however, has not been implemented consistently by the Italian Constitutional Court if we look at the very recent decision in matter of pensions, in which the court decided to declare this law unconstitutional without taking this new device it had invented or it had used just a few months before on postponing the effect of its decision. So the relationship between the Parliament and the Constitutional Court has usually been quite a good relationship, with some recent developments, as I said.
It's very interesting. The court has sometimes chosen to issue a judgment that has retroactive application, but on other occasions, most recently, as you suggest, in February of 2015, has said we will suspend the coming into force of our judgment until the day after the decision is issued, in which case it will not have retroactive effect. Very, very fascinating. Can I move on to another subject, Cristina? I just want to ask you two more questions. And one has to do with what is happening more broadly in Europe. Of course, Europe is now, there are now a number of conversations, more than conversations, movements, in fact, towards secession. And I wonder whether there have been any spillover consequences or any new legislation, any new scholarly discussions about Italian regionalism in connection with the larger conversation, the larger movements towards secession in and around Europe.
Actually, this is a very timely question, because there is a case pending before the Constitutional Court, which will be decided shortly, on secession. Because a region, Veneto, passed in June 2014 two laws, one asking to obtain more autonomy, which is also allowed in part by the Constitution, and the second one was to a regional law aiming to hold a referendum, a regional referendum on secession. And I must say that Veneto is one of the richest regions in Italy, so it is also a matter of fiscal federalism and taxation and its public expenditures. But the case was brought by the national government before the Constitutional Court and will be decided shortly, I think, for the unconstitutionality of this regional law. But still, I think the case of Veneto has also claims coming from other regions are significant in that they signal that there is a problem, ongoing problem with Italian regionalism, namely the claim of many regions to enjoy more autonomy compared to what they have, which has been neglected for years by the central government. And this is part of a broader problem because the very important constitutional reform passed in 2001 would have strengthened the autonomy, in particular the legislative autonomy of the regions. But the reading of this constitutional reform on the part of the Constitutional Court went in the opposite direction. So if you look at the text of the Constitution and the legislative competence in theory regions have, and what they have in practice, there's a huge difference. So the case law of the Italian Constitutional Court went in the direction of recentralization of legislative powers. And all these claims coming from the region went basically unheard. Also, and this is allowed by the Constitution, regions can ask to obtain strengthened forms of autonomy and to pick up some of the competencies that are for the state. However, this has to be approved by a national legislation. So many regions, including Veneto, presented these bills, which were never examined. So this is why I'm saying, not to justify, of course, these claims, but that there is a problem of coordination and cooperation between regions and the central government. Of course, the way the secession, the idea of secession, the principle of unity and indivisibility of the state is defined in each constitution is very different. So it's very difficult to compare the case of Scotland or Catalonia to the case of Veneto, because constitutional provisions are so different. And also the constitutional arrangement, talking about the UK. But still, there is a common problem, in which Italy is also part.
It's really interesting, Cristina. So we have discussed the new constitutional reforms underway in Italy. We have talked about recent constitutional court case law, not only with respect to domestic issues, but also with respect to EU and international law. We've talked about the relationship between the Constitutional Court and Parliament, and we've just discussed just a moment ago about Italian regionalism. I want to end, Cristina, with one question, and I want to ask you to put on your Nostradamus cap and help us look ahead to the next 5 to 10 years in Italian constitutional law. What are some of the issues, the major issues that you think will arise? What are, in other words, some of the unresolved questions in Italian constitutional law that you think not only need resolution, but likely will be resolved in the next 5 to 10 years?
Sure. Well, I think there are some important points that will be addressed by constitutional bodies and discussed by scholarship, and most of them really need to be fixed. Some of them deal with the problem of civil rights for what concerns, for instance, same-sex partnership, same-sex couples and same-sex marriage, which is an issue discussed almost elsewhere in Europe and beyond, and that has not been addressed by the Parliament yet. So there are many bills pending for approval. There was a case that reached the Italian Constitutional Court in 2010 on same-sex marriage, and the Italian Constitutional Court considers same-sex marriage as not in compliance with the Constitution. But we have seen movements not only in other member states of the EU, but also in the US, as well as in the case law of the court in Strasbourg that go in a different direction. So I think this is something to be fixed, hopefully by the Parliament, with a comprehensive legislation. Also, I think another issue will be the issue of immigration and the treatment and the protection of migrants. Because of the recent development, also in geopolitics, I see here a problem to be fixed on two sides. The first one is the sides of security, so security of the state, and illegal immigration. And on the other hand, there is also a problem of protection of rights of migrants. First of all, the right to dignity, and Italy in this respect is directly exposed to this problem because of the flow of immigrants reaching the Italian coast from the southern shore of the Mediterranean. But I think this will be debated in the coming years, and hopefully we will find a compromise solution between these two tensions, on the one hand security, on the other protection of rights. Also, I think that should the constitutional reform finally be enforced, the issue will be to see whether the problems with the Italian regionalism will be fixed, also because the Senate is supposed to become representative of regional and local authorities and no longer elected. So they will enjoy direct representation in the Senate. And also, I hope this will help to address some of the claims coming from the region, even if I have to say the constitutional reform goes in the direction of recentralization of legislative competence, which is coherent with the case law of the Italian Constitutional Court.
So this is a great list of things to look forward to, and on which hopefully we will get some clarity in the years ahead. Cristina, this has been really fascinating, but I don't want to let you go yet, because I would like to hear about the kinds of things that you're researching and writing about right now.
Yes, sure. Well, I'm currently focused my research on two main issues. One is the Euro crisis law, which is also part of a project at the EU law department, and the constitutional implication of the Euro crisis measures in the member states. And I'm looking this issue from the point of view of the relationship between the parliament and the constitutional or supreme courts in this respect. So how the Euro crisis law has affected this relationship. And also my research interest goes to focusing on the issue of secession, both in the relationship with the EU, so whether there is a link between these ongoing secession or movements and EU treaties and the positions taken by EU institutions, and also on the issue of secession in Italy.
Well, thank you, Cristina. I look forward to reading more of your work. I've read a lot of it already, and I've learned so much from it. So thank you for joining us today on iConnect to discuss with us developments in Italian constitutional law. It's been very interesting to me. So thank you very, very much.
Thanks a lot. It has been really a pleasure. Thanks for the opportunity.
Bye-bye.
Bye.